Good afternoon and welcome to The Law. This is your Legal Light. It is your health law. I'm Samson Lardi Anyanini. The Ablekuma North episode isn't just about ballots. It's a mirror held up to our legal architecture, institutional integrity, and constitutional maturity. Educating the public on these distinctions helps to inoculate democracy against misinformation and procedural overreach. Don't go anywhere. Stay with me because I return shortly to take you through the various laws that justify or do not justify the decision for a rerun and everything else that followed up. All the infractions that we witness during the rerun, what does the law say about each specific conduct? We'll be right back. So let's begin this way and stay with me because we're going to be doing a lot of learning and you have the opportunity to join us with questions as well. We want as much as possible to strip bare all the politics. Of course, as you know, on the law, we deal with the pure law. So we want to see if we can help you with really very good education to inform you in a manner that empowers you. So I'm going to try as best as I know the law to strip away the noise and dig into the legal aftermath of the rerun. We will look at the matters of the confessions of vote buying, threats and assaults to barefaced vigilantism, all of which are prohibited by law. You know it is prohibited. But what is the potential consequence you will suffer if you are caught in these acts? We will try to decode the implications or the criminal implications relying on the Constitution, that's the supreme law of the land, the Criminal and Other Offences Act, 1960, the Representation of the People Law, and the Vigilantism and Related Offences Act. So stay with us to help with this education. So on the 1st of July, the Electoral Commission on the 2nd of July announced through a press release that it had had a meeting with the two contesting parties, the NPP and the NDC. And the two were holding on to their entrenched positions on the subject of how to proceed to finish with the Ablekuma North election process. Then they announced that in the midst of the stalemate, they are going to do a rerun of the elections in 19 polling stations. There was uproar, particularly on the part of the NPP, because its view, which many of the public shared, was that the Electoral Commission had insisted for a long period that there were only 3 polling stations at stake. And all it needed was police protection to continue with the coalition, complete with it, and make a declaration, i.e., the declaration right after the election having become a subject of contest, and a court having ordered that the EC should go and continue with the coalition. Among the concerns that were raised was that the EC does not have power unless it went back to the court to get the power to do a rerun. Is that correct? So let's try if we can bust that myth for the first part of this, engagement or education. The Electoral Commission is working with laws. The first place from where the Electoral Commission draws its power is the 1992 Constitution in Chapter 7. And Chapter 7 is titled Representation of the People. And from Article 43 is the provision for the Electoral Commission. In Article 45, more specifically, the Constitution says the Electoral Commission shall have the following functions. It will compile register of voters. It will demarcate electoral boundaries. It will conduct and supervise all public elections and referenda. It will educate the people on electoral processes. It will undertake programs for the expansion of registration of voters, and it will perform such other functions as may be prescribed by law. So if you look at Article 45, Clause C, it says, the Electoral Commission shall have the following functions. And one of the functions, as prescribed in Clause C, is to conduct and supervise all public elections and referenda. That's the power the Electoral Commission has. But, as I explained many times, the Constitution deals broadly with power and the distribution of power, establishing institutions and how they should operate. And we use legislation, subsidiary, so to speak, or acts of parliament, to now begin to explain further and give the mechanics. So the Electoral Commission operates, apart from this Constitution, under the Public Elections Regulations 2020, CI 127. That was used for the 2020 elections and upwards. And it says that the Electoral Commission may conduct a rerun of elections in specific circumstances. Regulation 42 provides that the Electoral Commission may do a rerun if, after counting and any recount, two candidates receive equal number of votes. I'm reading from the law. It is important to do so. Two candidates receive an equal number of votes, and adding one vote would entitle one to be declared elected. It says the returning officer must certify the tie and forward the writ to the EC. The EC shall then conduct a second parliamentary election within 30 days of receiving the writ. A similar thing also happens under Regulation 44(2), already confirmed by the Constitution, for presidential elections. So if no candidate obtains more than 50% of valid votes cast, the EC is supposed to conduct a second election within 21 days, in which situation only the two candidates with the highest number of votes from the first election will contest. So the argument is being made that the EC's power to conduct a rerun in Regulation 42 of CI 127 is dictated or becomes apparent only when, after counting and any recount, two candidates receive equal number of votes. Since that did not happen, the EC could not do a rerun unless it had gone to the court and gotten the power of the court, the orders of the court, to do the rerun. Is this correct? Now, When you read Article 45, C, it says the Electoral Commission's functions include to conduct and supervise all public election and referenda. Question is, Ablekuma North, was the process complete? The answer is no. The process was not complete. They needed to finish with the collation and then make the declaration. At a point, because election materials have been burnt and destroyed, they were unable to proceed. So they had to depend on the two parties to submit their scanned copies of the pink sheets. In the validation processes, because they are using scanned copies, which are not, so to speak, the original copies, they need to be validated. And those to validate them are the Electoral Commission officials who were responsible in each of those polling stations. As it turned out, at the end, 19 became outstanding and could not be validated by the officers, or that the two parties themselves, whilst their officers appear to be initially amenable to these, you needed the officers of the EC to validate them. And since the validation could not happen, the two took entrenched positions. They needed to conduct a rerun to complete what they had started. That will appear to be consistent with the law, because their job is to conduct elections, supervise elections, conduct and supervise elections. If it is not complete, they are duty-bound to complete it, but they must do it lawfully. So in doing so, have they broken any law? Apparently, I cannot see one yet. When in 2021, there was an election petition to the Supreme Court, one of the issues that the Supreme Court had to pronounce on was that the Electoral Commission had made errors in its declaration and corrected them. And because of that, the results needed, as it were, the contention was that the results had to be invalidated. What did the Supreme Court say? The Supreme Court said the Electoral Commission has power, part of its administrative powers, to make corrections in good faith and make them timeously. It is a basic principle of law. Once they did that, there was nothing wrong, for as long as it does not affect the outcome in an arbitrary way and it is transparent, it was acceptable. It is the same principle that you can use for this. If I went to court, in fact, courts, when they give judgment, they give rulings, they make orders, and they make errors. They are allowed by law on them, by themselves, the judges, to make a correction. Sometimes we call the slip rule, to make a correction. If they are doing something they haven't completed, they are entitled to finish it up. So on that score, I'll say the Electoral Commission did not do any wrong. Now, once we're doing two parts. I finish this small part, then we go to the manifestations that we saw on the day, the violations, complaints that have come up, and go to the specific laws about them and what the sanctions could be. Second thing that I think we need to help in educating ourselves about has to do with the complaints that when the party that was aggrieved, the NPP, went to the court to try and stop the process, the judge ought to have stopped the process. Now, simply, they went for what is called an interim injunction. When you are going for an interim injunction in the court, there are normally three basic principles that guide whether a court will give the injunction or will not grant the injunction. First, it must be established that you really do have a case in law. You have a right that has to be protected. The court must also look at your evidence to see if in granting, we call the first part, we call it that there's a prima facie case, and you have heard prima facie very often, that there is, something that is serious, and is serious issue to look at. Then the court has to now look at the balance of convenience. Which party stands to suffer more if the injunction is granted or is refused? And finally, it must ask itself whether there will be irreparable harm, whether the damages will be adequate to compensate if the injunction is not granted. So this is what the court did, and the court held that the Electoral Commission ought to be allowed to go ahead and perform its function. And if the party that is seeking the injunction, that's not the main case, after the process, after the main case, they are successful, they will be compensated. So that's what the court came to. Now I'm coming to a final point. During the campaign, there was what appeared to have become a common message, a campaign message on the part of the NPP, that the NDC was seeking an absolute majority because they need 184 to have a majority, an absolute majority, to be able to do, almost anything they want to do in the House. And that with this election, if they won it, and they have won it, this is what it gives them. Gives them enormous powers in Parliament. And that once they got that power, it will enable them to amend the Constitution so that President Mahama will be allowed to run elections in 2028. Let's attempt to bust that myth also. And those who are making that comment include lawyers in the NPP. And I'll show you a footage where one of the lawyers of the NPP, former minister, was engaging some of the electorates at Ablekuma North and telling them exactly what I just told you, that the NDC wants that kind of majority in Parliament, so they will amend the Constitution and allow John Mahama to be able to run for a third term. The video you just saw was Samuel Abujinapo, and he was very emphatic about this. You have heard many members of the NPP, you have heard even the minority leader, suggest that there is a certain grand plan to change the Constitution somewhat and let President Mahama run for a third term, because he's already run first term, and this is his second term, and when it ends, according to the Constitution, he can't run anymore.
We have to test in Parliament, so we make national constitution. Mahama be 10 elections 2028. We say in terms of grace, and our opinion time. Let us say we for now to change. Na yen share party, na yen share mind, na yen team.
So you heard him in very clear terms. Is that correct? If the NDC has the kind of majority it now has in Parliament, can the NDC in Parliament change the Constitution to allow John Mahama to run a third term, so to speak? That is an absolute incorrect statement to make. it's misleading, it's misinformation. You could say it's actually disinformation to a large extent. Why do I say that? The executive chapter in chapter 8 of the 1992 Constitution is what you call part of the entrenched provisions of the Constitution. When we say a provision is entrenched, it means it is not amenable to being amended unless through a referendum. So, which provisions are up for consideration? Article 66 is the one that deals with the term of office of the president. Article 66(2) says, a person shall not be elected to hold office as president of Ghana for more than 2 terms. A person shall not be elected to hold office as president of Ghana for more than 2 terms. Now, what constitutes the 2 terms? Article 66(1) says, a person elected as president shall, subject to clause 3 of this article, hold office for a term of 4 years, beginning from the date on which he is sworn as president. So you can only be president in Ghana for 2 4-year terms, cumulative 8 years. After that, you cannot become president again. This provision I have read to you, 66, is an entrenched provision. Let's appreciate what will happen if you need to amend it, what you must do. If you need to amend it, you must go to Article 290, Clause 4. Article 290, Clause 4 is very clear, and 290 is clear by saying that that provision, 66, is entrenched. Then it goes on to say, to amend that provision and any other provision which is entrenched, you need at least 40% of the people who are eligible to vote in an election to turn out and to give their endorsement. Out of the 40%, you need at least 75% of those 40% of eligible voters turning out and voting yes to endorse a change, including a change in Article 66, Clauses 1 and 2. Therefore, it is impossible for Parliament to amend the term limits for a president. So that campaign was misinformation. I'll take a quick break here and I return to the second part about what we saw on the ground. Threats, vote buying, vigilantism acts, assaults, and all of that. What does the law say about them? This is the law. It's your legal light. It is your health law. Elections belong to all of us. The laws punish wrongdoers. The laws exist to preserve fairness, protect lives, and promote peaceful participation. So in this structured, public-facing legal education presentation that I'm making to you, is intended to highlight the consequences of the prohibited acts during the electoral process, particularly those that arose in the Ablekuma North rerun. I've done the first segment of a different nature, and this is the second segment. And shortly, we'll be opening the phone lines for you to join. So, Linda Oklu, is that her name? She's the regional minister, Greater Accra regional minister. She was heard during the rerun speaking to the media and saying this. We want to answer the question if what she said is crime or not.
here to support our sister, and we are here to make sure that we win the seat for NDC.
All right, Honorable, there's been a couple of issues or concerns raised with regards to vote buying. I don't know if you've heard that your opponents, that's the MPP, they've raised concerns that they whenever their members come around to vote, they see the others put them aside and all that. I don't know if you've heard that.
My dear, this is not news. I mean, every election there's a vote buying. I mean, so if we are buying votes, they should also buy their votes. I mean, we have members who traveled all the way from Kumasi and they have to come and vote. So if such people come, you have to give them TNT to go and vote. I don't think it's a vote buying. Are you guys? So if you think it's a vote buying, you to go and buy their vote. It's as simple as that.
But there are concerns that it could affect the integrity of the process. Are you
I mean, which one is integrity? If someone is loyal to you, why not? The person.
Right. So what the minister speaks about and justifies and actually invites others to do is outright crime. Yes, outright crime. In elections, bribery, personation, treating. I've explained treating a number of times. We'll do it again. Myself and Mamavi, we took time to explain that not too long ago. Treating, undue influence, and similar such offenses, they are crimes punishable under our laws. So let's quickly look at which part of the law deals more specifically with this kind of crime. We're referring to the Representation of the People Law, 1992. Section 33 is about bribery. And it says, a person commits the offense of bribery if he directly or acting through another person gives money or obtains an office for a voter in order to induce the voter to vote or refrain from voting, or corruptly does such an act on account of a voter having voted or refrained from voting, or makes a gift or provides something of value to a voter to induce the voter to vote in a certain way or to obtain the election of a candidate. And it says again that, or if he advances or pays money or causes money to be paid to or for the use of a person with the intent that that money or part of it shall be expended in bribery at an election. If before or during an election, he directly or indirectly by himself or through another person acting on his behalf receives, agrees or contracts for money, gift, a loan or valuable consideration or an office, places and a place of employment for himself or for another person, and so on and so forth. Now, Section 34 is about treating. And it says a person commits the offense of treating if he corruptly either himself or through another person before, during, or after an election gives or provides or pays wholly or in part the expense or the expenses of giving or providing meat, drink, entertainment, or provision to or for any person for the purpose of corruptly influencing that person or another person to vote or refrain from voting on account of that person or another person having voted or refrained from voting or being about to vote or refrain from voting. if he corruptly accepts or take any meat, drink, entertainment, or provision offered in the circumstances and for the purposes mentioned, you have committed the offense of treating. Then 35, as if the lawmaker wants to fortify it beyond doubt, says a person commits the offense of undue influence if he directly or indirectly through another person acting on his behalf makes use of or threatens to make use of force, violence, or restraint, inflicts or threatens to inflict on another person a temporal or spiritual injury, damage, harm, or loss in order to induce or compel that person to vote or refrain from voting on account of that person having voted or refrain from voting. When you do all these things, the law says you have committed an offense which has to be punished by the law. So, to say that it is okay to give money so that somebody will come vote for you because that person doesn't have money for transport does not excuse this offense. Straightforward, it doesn't excuse. Because even if you were giving them food or drinks or giving them a form of entertainment for the purposes that they are going to vote for you or your candidate, you have committed the offense and you are subject to punishment under this law. And the punishment you suffer does not only, or is not only limited to you suffering a term of imprisonment. It includes you being banned from having the opportunity to vote in subsequent elections. So we need to take note of that. You could go to jail for this offense, or you suffer the jail, and in addition to the jail, which you can suffer up to 2 years imprisonment, you will then lose the opportunity to vote in subsequent elections, at least in 2 subsequent elections. That will be like a period of 8 years. So we need to take note of that. It is important. You don't want to lose your right to be able to vote in an election. So we take note of that. Thank you very much. So that is outright crime. Then the only problem, small problem, I may say about that is that the police cannot prosecute the offense unless they have a written consent of the Attorney General to prosecute, according to Section 42 of this law. If the police want to prosecute the regional minister, they will need the Attorney General's express consent in writing before they can prosecute her. So that's the problem we have identified for a long time, but we don't seem to want to solve it, because the truth is that we know in our politics that a party in government will hardly give the endorsement for their people or their members to suffer prosecution. Now let's go to this next, video as a result of the things that happened at the place. There are 2 of them, one involving Mavis Howard-Kumsin and one involving another MPP or executive by name Lloyd, who was also, maltreated. There were also journalists, 2 of them who were slapped by police officer, one by police officer and one by clearly a thug. What you are looking at now are exchanges, an altercation where there are exchange of words, there are threatening words that are used, threats of harm, leading to Howard Kumsing, the former MP and former Minister for Fisheries, being pushed down and beaten. He's now being rescued, as you can see in the footage. Right. And people are running helter-skelter for their lives. And this is the second one where an MPP officer is being beaten. They are kicking and hitting him. Some actually jumped with their both legs, stamping him on the ground. Well, fortunately, he's also rescued. So that's a police officer now slapping a journalist. That was a hefty slap. And you may have heard it already, how the slap felt. Very hefty slap. A GH1 journalist. And this is a multimedia Joy News reporter who was also attacked by the person you see in your shot. He was hit in the face. So now let's answer the question. These incidents, the 4 separate incidents that we see, is there anything criminal about them? Absolutely yes. Where they were issuing threats, insults that were in the form of threats, threatening to harm. In our law, in section 74 of the Criminal and Other Offences Act, 1960, it says, quote, whoever threatens any other person with unlawful harm with intent to put that person in fear of unlawful harm shall be guilty of a misdemeanor. Some of the threats we understand actually go to the threat of death. Section 75 of the same law says, whoever threatens any other person with death, with intent to put that person in fear of death, is guilty of a 2nd-degree felony. The first one, threat of harm. Just threats, saying words, showing action, behavior, demeanor that suggests that you are putting the person in fear of harm, and the harm is unlawful. Remember, it's only the police that may exercise a lawful process that may lead to harming you and which will be questioned by a court to determine whether it can be, excused or not. So if you put the person in fear of harm, fear of it, not that you have harmed them actually, it's a crime. It's a misdemeanor. By misdemeanor, it means the prison terms you may suffer will be up to 3 years. That's the maximum you may get for jail. And those issuing the threats of death, I'll kill you. And then they do things and you feel that you can apprehend fear of death because of all they are doing. Maybe they're holding some weapons and so on. Just that, not actually causing death, using words and conduct also is a crime in Ghana. And by the law, it is a 2nd-degree felony. It's not a misdemeanor. Misdemeanor gets you to a maximum of 3 years. 2nd-degree felony in this nature gets you to a maximum of 10 years in jail. So the threats are unlawful. In section 76 It says, harm is unlawful, which is intentional or negligently caused, without any of the justifications that the law speaks about. In section 84, it talks about assault. This is where all the things they got involved in now lead to physical beating, the slapping of the journalist. And we see bruises or injury on the forehead of the GH1 journalist. And then the multimedia journalist, she got slapped, hit also by her cheeks, around her neck. And you can see clearly that she's injured. That is assault. In fact, these assaults have moved beyond mere assault, but assault with battery. And the law deals with them differently. It says, whoever unlawfully assaults any person is guilty of a misdemeanor. I've told you what a misdemeanor can get you into in the first place. You're only lucky if a court decides to give you a fine. And there are kinds of assaults. There's assault that includes assault and battery, assault without actual battery, which may be in the form of words, and imprisonment. And imprisonment will not be in the sense that the person has arrested you and taken you to a prison, but they threaten you such that you have to, if you are in one place, you feel you must stay there for your safety, or such that you are at a point where you feel if you move, you must move. But if you move, they will harm you. So they literally have imprisoned you. And all of that, the law says, is punishable. So how does the law define assault and battery? In section 86 subsection 1, it says, a person makes an assault and battery upon another person if without the other person's consent and with the intention of causing harm. So the person didn't consent to you slapping them or hitting them. And also the act you're doing physically, you intend to cause harm, cause pain or fear or any annoyance to that person, or of exciting the person to anger. You touch the person forcibly, or you cause that person or an animal or any matter to forcibly touch that person. That's assault with battery. A person makes an assault without actual battery on another person if by any act apparently done in commencement of an assault and battery, he intentionally puts the other person in fear of an instant assault and battery. Mentioned that earlier. A person imprisons another person if intentionally and without the other person's consent, he detains the other person in a particular place of whatever extent or character, and whether enclosed or not enclosed, or compels that person to move or be carried into a particular direction. You are committing an offense and is punishable by law. We see that in these processes, there is damage to, some property. If you are causing damage, that is also punishable by our law. If you cause damage, it can be punished in two levels. It can be punished as a misdemeanor. It can also be punished as a second-degree felony. If you cause damage to property in such a manner as to cause or to be likely to cause damage to life, you shall be guilty of a first-degree felony. So, an example that they push perhaps the canopies and push them in a way that they fall, and then they cause the death of somebody. That kind of damage to property can lead to first-degree felony. And first-degree felony will go to life imprisonment or less. If you are holding a weapon, an ammunition, all of that is not allowed by the law. If you are dealing with explosive firearms, all of that is not allowed by the law. So if you are carrying weapons there, you must explain why, and you will be in trouble for carrying the weapons, offensive weapons. And the weapons the law looks at is not only gun. It can be anything you have adopted. It can be a stick or whatever it is, a stone adapted in a way that can be used to cause injury. So that is be deemed as an offensive weapon in the law of Ghana. Your conduct can also lead to what is known as a conduct conducive to breaches of the peace. You are shouting, you are doing all sorts of things that can lead you to a misdemeanor offense, and you'll be punished for it. And I'll say the final one as I take your calls now. We passed what is known as the Vigilantism and Related Offences Act in 2019. And through it, we banned all the vigilante groups in the country. So many of them. We banned all of them. If you are involved in an act of vigilantism, directly or indirectly, including by aiding or funding those activities, you could be found guilty, and you will look to a term of imprisonment not less than 10 years and not more than 25 years. Let's take note of that. Who is my first caller? Hello, Ampafo. Good afternoon. Welcome to the law.
Thank you very much, Mr. Aini.
Ampafo, forgive me. We lost you. Jacob. Hello, Jacob.
Hello, sir. Good afternoon.
Good afternoon. Let me hear you.
All right. I want to touch on the bribery issue by the regional minister. I think the Attorney General should kind of do something about it concerning its effect on the country, because paying or giving someone money to vote or something is actually an offense. And also concerning the attacks on journalists and other people at Ablekuma North, I think this is not the right place we should go. The government should sit up with the security issues so that as time goes on, we'll have a peaceful country. Mind you, we are going to Akotia for an Eskumis by-election, and the same will be happening there. So I would like the government to sit up and beef up security.
Thank you very much, Jacob. Let's go to Abu in Tamale. And those involved in the Vigilantism Act, you see, once they group together and they are acting with one mind together as a group. You heard about Blue Army and Green Army, and some of them holding weapons. And I say weapons is not only arms, okay? All of those things involving acts of vandalism and unlawful harm and damage and so on and assault will be treated as vigilante acts. And you could go to jail for between 15 and 25 years. And after that, you will also be banned from contesting public elections or holding a public office or a political party office for 10 years. Rauf, you're calling us from Tamale. Let's hear you, Rauf.
Yes, good afternoon.
Good afternoon, let's hear you.
Yes. Please, your program is very, very good. Your program is very, very good. But I will plead with you to enforce the authority to do the right thing, because they know the right thing. And what you are saying, all they know it. But anytime such a things happen, there is no any reaction. So that is my problem.
Okay. There must be action. If not, we compromise our own collective security and peace. That is Abu from Tamale. Hello, Rauf.
Hello, Council.
You're also calling from Tamale. Let's hear you.
No, I'm calling from Second D.
Second D, let's hear you.
Okay, so my question is, how Akumson was standing there idle, and then she removed a pepper spray to protect herself. So if in the case it was a gun or a stick or a knife that she used it to also throw it to somebody and the person dies, is she liable by the laws of Ghana?
Of course.
That instance.
Of course. Thank you very much. So any kind of thing you do, and the youth especially, you need to take caution. You do these things, you may just find yourself in jail for 3 years, for 10 years, for 15 years, for up to 25 years. So be careful. It's election. You just go and vote quietly and move away. If you don't have anything doing at the polling station, don't go there. Who's up? Who's next? Kwame, you're calling us from Kumasi. Let's hear you.
Good afternoon, my brother.
Go ahead, Kwame.
Yes. Sometimes I blame you journalists. I blame you people because in the run-up to the elections, it was obvious some of you wanted the MPP government to go. So no matter what the NDC tax did, you people did not complain.
Are you talking about the Ablekuma Rerun, or you're talking about the main elections in 2024?
I'm talking about the main. That is what is repeating itself here.
Okay, so this is what we are talking about. We're talking about the law. We are talking about violations of the law in elections. I need to caution you that this is not a political program. This is a legal education program. The violation of laws during elections and their consequences. If you have comments on that, we'll take them. Okay, we lost Kwame. I think this may be the first day Kwame is joining the show. This show is not a political program. And let's be reminded, regardless of what a journalist does, regardless of anybody, what they do or say, you don't have a right to lift your hands on them or injure them. When you do that, you are committing a crime and you'll be punished for it. People are entitled to belong to political parties. Political parties are not criminal organizations. Otherwise, they will not exist. So if a journalist decides that they are supporting one party or against the other, it is their right to do so. All right? If a journalist decides that they want to be neutral or, as it were, impartial, that is also fair game. It is not the reason you should attack anybody. If you attack anybody, you commit either acts of threats, acts of harm, acts of damage. You have to face the law. So this has been the law. It's your legal light. It is your help law. I hope we have assisted you to understand the law and to take a cue in your conduct going forward during elections. I'm Samson Lardi. Have a good afternoon.